Today's topic really is one of those that are very important to hospice, but also to anyone in healthcare. And that includes patients and families, because we're going to be talking a little bit about not just the objectives for advanced directives, but the different kinds and what we need to do to make this happen. So let's go ahead and get started here. All right, so our objectives today are describe the Patient Self-Determination Act. None of this would be made possible if you didn't understand the Self-Determination Act. So I'm going to go over that with you and explain to you what you need to do upon admission with a patient and make sure that they indeed get a copy of that. We're going to list the requirements that a hospice is to follow at the time of admission in regards to the Affordable Care Act, the Self-Determination Act, the things that come into place every year that people tend to overlook when it comes to patient rights. So that's one of the things that's listed under patient rights. And then we'll discuss advanced directives and how end-of-life decisions are made. There are different types of advanced directives. We're going to go through some of those. We'll talk about the advantages and disadvantages. And I know that you could probably think of a lot of advantages to having an advanced directive because you hear me talk about that all the time. But believe it or not, the disadvantages I categorize are things that when you have someone already on service and a question comes up or decision needs to be made about the care and there is no advanced directive. That would be a disadvantage of not having one. And then we'll identify some resources that you as a healthcare provider can share with patients and families. There are 3 do's of effective life care planning, the things you should do, and then there's also disadvantages of having them. And the 2 disadvantages we'll talk about a little bit later. So let's begin by saying, do you have a plan? You always want to start by asking a patient if they already have a healthcare plan and what their wishes are. So it's very important for us to know and understand what is important to them. I think most of us that do hospice admissions or any type of admission, whether it's in a hospital or a home health, some of us are very proactive about, do you have an advanced directive? But we don't take it a step further and say, what exactly do you have? Do you have a copy of it? And making a copy of it and putting it in their file. It not only tells us the type of advanced directive they have, but it tells us what their wishes are. And some people are very explicit about what they want and what they don't want. So it's very important for you to make sure that your patients, you're asking them if they have a plan. So why do you need an advanced directive? Well, it helps make your wishes known. I'm sure most of you could probably tell me about situations where a patient was at end of life and there was more than one family member or more than one sibling, and there is dissension there and not an agreement or a collaboration about what they're going to do for their mom or dad. So it's really important that you make sure that they make their wishes known and that it's in writing. It's also used when you're not able to make decisions for yourself. And it gives, I truly believe, it gives your loved ones the opportunity to have peace of mind. I know when my parents were dying on their deathbed, they had things in place. And that was only because years ago, I had started having those conversations. And, Thanksgiving is coming. It's a perfect opportunity, even though you're not going to be having a bunch of family over due to the pandemic we're in, but it's a perfect opportunity for you to have those conversations with your immediate family. And those are, Thanksgiving is a good time for that, when you do have family gatherings. And also making sure, especially even when you're younger, in your 20s and 30s, to start thinking about how you want to be cared for in the event that you can't make decisions for yourself. So a little statistics for you to understand is most Americans, 88%, do feel comfortable talking about advanced directives. The problem is only 42% actually have some sort of a living will. So that tells us that we're still a society that actually people have to be pushed into place to do something about that. And even though you may be perfectly healthy, you never know what life's going to throw at us. It is very important for us to understand what the plan is for someone in case they can't make those decisions. So it's really interesting to know that most of us agree we should have them, but very few of us actually have those in play. So what is an advanced directive? It's a written statement of your wishes, your preferences, and choices regarding all of your healthcare decisions. And it's really considered to be a tool that we use to communicate those choices with a roadmap to explain to different people what we want done. So when you have an advance directive made, you can either, we'll talk about how to do that, but you download the forms off the internet, or if you see an attorney because you want to have a trust done, whatever your choice is, you need to make sure that that is in not only a safe place, but that the person that is going to be making those decisions for you has a copy of that, or a copy of that is locked up for the future, so that this is what you tell your kids. This is where my important papers are. I can remember my parents used to take cruises and trips after they retired. My mom would write this huge, 3 or 4 page letter to me. And really it was nothing, about how are you? It was just a list. This account's in this bank, and this is in this bank, and here's where our advance directives are. And I always held on to that letter, even though she would write the same darn thing every year when they would travel, because once you have it once and they haven't made any changes, it's important to have. The second part to that roadmap is, if they do make changes, are they communicating those changes to their loved ones? So people may have the same will for many, many years, and then something happens and they change it. They need to make sure that that's communicated to people. So maybe, like with my brother who just recently got divorced, he just changed all of his because his wife is no longer in the picture, and made sure that I had a copy of all that. So things like that people don't typically think of. So it's written instructions about future medical care, especially if you're seriously ill or injured and you are not able to speak for yourself. And that happens sometimes to young people that are 18, 19, 20-year-olds that I used to take care of at John C. Lincoln many years ago, would come in unable, seriously injured, gunshot wounds, car accident, motorcycle accidents, where they were essentially brain dead and they couldn't speak for themselves. And then decisions would have to be made about their care from that point forward. So you really would like to have things done in place for your loved ones so that you don't put that burden on them. So there are 2 types of things I want to focus on now. And one is a living will, where you can write out exactly what you want to have done. And that is, also important to have a medical power of attorney. There's 2 different types of power of attorneys, but there's medical and financial. But the medical power of attorney is the one and the only one that can make decisions for you in the event that you cannot make them for yourself. So it's important that you have that. For a living will, I was real detailed with mine. When I knew I was having back surgery, I wrote down, in the event, I had a stroke, I would want speech therapy for 6 weeks to 3 months. If there's no improvement, then I don't want any. I pretty much basically wrote out exactly what I wanted. You don't have to be that explicit, but I think most nurses are. So that just comes with the territory. But if you are doing any sort of a will, you want to make sure that you're putting in exactly what you want. The Self-Determination Act, which I mentioned earlier, is a public law. It's 101-508, Section 4206 and 4751. It was enacted by Congress on November 5th of 1990 as part of the Omnibus Budget Reconciliation Act of 1990. This is where we give people the right, it's a patient's right, to determine how they want their care to be and who they want to make decisions for them. So you must follow the law and respect the Reconciliation Act of 1990, the Self-Determination Act. So it refers to the right of a competent adult to make their own medical decisions, and includes the right to complete an advance directive saying how or who you want to make those in the event that you become incapacitated. So there's actual law, the Patient Self-Determination Act, that most attorneys that do elder law will talk about when they're working with you to do some sort of advance directive. So when you admit a patient onto hospice specifically, we use a patient book that we have all kinds of information for them. And in that book, we have listed patients' rights. And one of the rights is to be able to make decisions. So make sure that you are explaining all of this at the admission process. Very important. According to this act, at the time of admission to a hospice, the following must happen. You must provide the patient written information concerning these rights under the state law that you're in. So for us, it's the state of Arizona. We have in our patient and family handbook, is what we call it, or teaching tool, information about this law and about patient rights, and that comes under patient rights. Whatever state you're in, you need to make sure that you have that in your hospice booklets or home health booklets, whatever it is you're giving them. So the hospice must also provide a written statement of their policy implementing these rights. So in addition to having this information in our book that we give to patients and families, we also at Arizona Care Hospice at all of our locations have a policy that specifically says how we're going to do this. And we document in the patient's records if they have executed an advance directive. We have it in our EMR. It's a question that we ask, we check off, and then we should also be putting not only the type that they have, we should be asking for a copy and downloading that into patient documents under the EMR that you use. So we are forbidden to discriminate any medical care based on the fact whether they have one or not. So for example, when we admit patients onto hospice services, if they don't have an advance directive, which happens not all the time, but it happens quite frequently, it doesn't forbid us from admitting them onto service. It is our responsibility as nurses and social workers and chaplains, specifically the professional IDG team, to talk to patients and families about this. You know, I notice you don't have one. In the event that you live alone, in the event that you're not gonna be able to take care of yourself, who do you want us to call, or who do you want us to communicate with about your wishes? So this piece about advance directives is very important. The surveyors will look to see not the fact that they don't have one, but did you have that conversation? And have you given them information on how to do one in the event that they need it? So you must comply with all state laws regarding advance directives and provide education about this to the staff. So that's part of the reason why you're having this, or you've signed up for this webinar today, because you want information on advance directives so that you in turn can do a better job. And it's my obligation to make sure that we are providing you with all the education on any changes in the law, changes in status in regards to any type of advance directive. So we want to make sure that you are following, for example, the state law on DNR, the colored paper that's to be used. In Illinois, it's pink. In Arizona, it's orange. I have a list of all the different kinds of papers. So you have to remember when you're doing your DNR that you have the appropriate color of paper for the state that the patient resides in. Medical power of attorney is a document that specifies who you want to make decisions about your medical care. And this person is authorized to speak for you only, and that is only if you're unable to make your own decisions. So let me just emphasize a little bit about this that I see quite often in our practice. That doesn't happen all the time, but it does happen. So if you are admitting a patient onto hospice, no matter what the diagnosis is, and they are competent to make decisions for themselves, they have not been declared by the court to be incompetent, there is nothing in their history that says they have any type of dementia, then they must sign their own consents and make their own decisions. However, in the event that they cannot do that and they do have dementia, or for whatever reason they can't make decisions for themselves, you must use the designated person that is listed in their advance directive as their medical power of attorney. So if someone's husband is the decision maker, then that's the one you must use. You cannot use the daughter or the son or the aunt or the uncle when there is clearly listed as the number one person as their medical power of attorney. And sometimes we see in our admission packets that someone has gotten another relative to sign them onto service, when essentially it should be the medical power of attorney. So surveyors will look for that, will read those and see who that person is. So it's very important that you follow the law and who's to sign paperwork. So a medical power of attorney also has other names in case you come across this. So one of them is, a healthcare proxy or an agent. They're the healthcare surrogate, and also can be durable power of attorney for healthcare. So someone who also has the financial side could also be the same person to do the medical side. However, you do need to clarify that and make sure that one and the same person is listed as both. So a power of attorney, a patient can name the decision maker. So they can name anybody. So just because they have a wife, a husband, a son, or a daughter, they may not want any of them, and they might want their neighbor to be the person to make those decisions. You have that right to make that person known. You can also name a backup decision maker. So, for example, we have one patient now who her husband is the medical power of attorney, but in the event that he can't make decisions, she has one of her daughters as the backup. So, and remember, it takes effect only when you can't make those decisions, and you must specify the certain treatments that you want them to make. And only those people on the form, listed on the form, are the ones that can do that. So this also supersedes next of kin lists. So, we have this next of kin list that we use if there's no one. So for the medical power of attorney, if it's not listed, then we'll go through, the next of kin list. This should be witnessed. You should have a witness for this. It does not need to be notarized. You don't need to have a lawyer for that. So the hospice social worker can institute those papers for you to have a medical power of attorney. And you can find those papers online. And then the person designated can only make decisions regarding medical care. So this person that does the medical decision making for you that's listed cannot make decisions regarding your finances or your financial package. So the durable power of attorney is someone who does the finances or the property, totally different from the medical one. You can name someone to handle finances for you if you can't make decisions for yourself. This does not cover healthcare decisions, but this person can also be the same person that you use for medical. It can be one and the same. Or some people, like I know one family, they have their son as their financial power of attorney to do all the financial stuff because their daughter is not financially, savvy or understands finances, and she does the medical decisions. So it all depends on the family and what they want. For durable power of attorney for finances, it does need to be witnessed, it does need to be notarized, and it needs to be drawn up by an attorney. So we can't just draw up, assets and financial property. And there are many, many attorneys throughout the country that do a very good job of this. A DNR. So this states whether or not you want to be resuscitated in the event that you have cardiac arrest. It can be full or modified. You do need to have an MD order and a signature for this. So you do need to have a physician order because this is considered a medical order. It does not need to be notarized. It does not need to have a lawyer, but it does need to be on the state-specific approved colored paper that I talked about earlier. So DNRs are interesting because you want to make sure that you explain to the patient and family exactly what could happen in the event that their heart should stop. And there's multiple statistics on that. So explain to them that death, not be delayed. You choose what you want and what you don't want. So it takes effect when you can't make decisions. It needs 2 witnesses for a living will, and it does not need to be notarized and does not need to have an attorney. So the living will is something that is really spells out that you do while you're living. It really does. So while you're alive, you spell out what your wish is in the event that something should happen to you. And you don't have to have that notarized or have a lawyer for that. So you can even write that out. Although there are state-specific papers on the state of Arizona website specifically for a living will, should you need to do that for your family. The last will and testament is different. This deals with distribution of your estate after your death. It states the patient's wishes. It doesn't cover any healthcare decisions. It does need to have a witness. It should be notarized, and a last will and testament should be drawn up by an attorney. There is many people to this day that still prefer, especially elderly people, to have a will. The only problem with having a last will and testament is once you die, that goes to probate, and it could take a while before the distribution of those funds occur. Whereas if you have a trust, it's right then and there, and everything's settled right away. So that's a difference between the will, the last will and testament, and a trust. So just so you have that information. There's also such a thing called 5 wishes. That is when they're booklets that a lot of states recognize, except in many states. We have them here at Arizona Care Hospice. We have also sent those out to our patients and families. Should you have a patient or should you be a family member that's listening to this presentation today and you want a copy of the 5 wishes, you can have that. We will send that to you. So it names a decision maker. You fill out like this book. You can name backup decision makers. Takes effect when you can't make decisions. Only those people that you have listed on the form can make those decisions. It supersedes next of kin. And as with many other things, does not need to be notarized, need an attorney, but it is accepted in many states. And a lot of people choose to go through the route. When we were on K-Room Radio, I think it was a couple of months ago, we talked about the 5 Wishes booklet. And we had a lot of people call in on the radio requesting copies of that, especially in the Payson location. So make sure that you have those in your office if you are a social worker for sure, okay? Surrogate decision makers, they're used when patient has no one to make decisions for them. Usually a physician is a person that names those and follows the next of kin list. So if you go through, there's no, husband, wife, there's no children, there's no friends, there's nobody, then the physician usually will name someone and will apply for a fiduciary. This needs to be witnessed when you do this. It does not need a lawyer be notarized, but there's paperwork for that where the social worker will be able to get those downloaded off your state website, and then you can put in information on a decision maker for a surrogate. So a next of kin is used when there's no advance directive. That is if we don't have any information from the patient on an advance directive and they do have family. So it goes through a progression of decision makers, and it usually is in this order. The first, of course, is a guardian. If there is a guardian for someone, remember, a guardian is appointed by the courts. So if someone, went to court to have a guardian appointed for them, then that's the person that needs to make the decision. If there is no guardian, then the legally married spouse. If no legally married spouse, an adult child. Then the parent, an adult sibling, adult grandchild, close friend, and then a guardian of the estate, which would be the last thing on the list, because remember, a guardian of estate typically doesn't make medical decisions. But if you go through your next of kin list, according to the courts, then that person is the last one on the list if there's no one else. So usually somebody has 1 or 2 of these in between there, so we're usually okay. Let's talk a little bit about guardianship. So the guardianship is used when a patient has no advance directives and can be used when a power of attorney is acting inappropriately. So let's say someone has a power of attorney and it's medical and financial, and according to whoever, a family member, they feel they're not seeing or doing things in the patient's best interest. So they could contact an attorney who in turn talks to the patient about, or the power of attorney, about going to court and taking them to court. You do need to have an attorney for this, and you must go to court. And this guardian is appointed by the court, and it can be a family member or it can be an employee of the state. And it definitely can supersede next of kin. So, for example, if it's a child, a disabled child, that you're going to go to court for to have a court-appointed guardian, the courts automatically will appoint that child under 18 years of age with an attorney. And the attorney will be paid for by the state. So it's important for you to understand that most of the practice that I do is not with children, it's mostly with elderly people or healthcare stuff. But if you do work with disabled people or people with disabilities, the guardianship is a very important thing. So it's not cheap. It costs somewhere around $3,000 or $4,000 to appoint a guardian. So if you are going to go that route, just know that you have to have an attorney, that your person you want to be a guardian for is going to have an attorney, that it costs about $3,000 or $4,000, and that gets renewed every year. But you don't have to pay $3,000 or $4,000 every year, but you do have to pay a small court fee to keep those up every year when you do have those things renewed. There are terms that I want you to be aware of that the judge looks at. Most judges that I've worked with will allow us to put on forms that a patient cannot sign consents because they lack capacity. Statement just simply means that the patient's unable to make decisions for themselves, but that term is acceptable. What's not acceptable from us as healthcare providers is the word incompetent. We cannot write that on someone's admission information. That's a statement that is a legal term that comes only from the court. So if the judge declares someone incompetent, he or she will put that on the paperwork, but we cannot put that on. We can just say lacks capacity. So advanced directive information, here's a couple of places that you can go to get information. Contact the Arizona Secretary of State. Contact the Arizona Attorney General Office for a copy of the life planning packet. There is on the Arizona website for the Attorney General what they call a life care planning packet. And you can also contact AARP for your state-specific advanced directive form. So that's very important. And this is just the state of Arizona. I know there's some of you that have logged on, that have registered, that are not from Arizona, that are from another state that I do consulting with. Just know that you would have to contact me and I would put you through to your state attorney general's office, which I've done for you in the past. Advanced directive advantages. Remember we talked about, I'm going to tell you some advantages and disadvantages. The advantage to having one, and this is for all of us, is that you're in charge of making your own decisions. And here's a good thing about that. You can change those documents at any time as your life goes on and your priorities change or your life changes. And because these exactly express your wishes. And the forms are available, as I mentioned, at www.caringinfo.com. So disadvantages is advanced directives may not be available when you need them. So it could be you've admitted someone, you forgot to do that important piece of information. Now we get to the point where the patient can no longer take care of themselves. There's no advanced directives in place. And then what do? We call our social workers in a panic and say, help us, help us. But in essence, if you work very closely with your social worker and IDG teams, you can do this together. And at Arizona Care Hospice, we have wonderful social workers at all of our locations that not only help our own patients, but are available to help people in the community. So if they're not really available in a patient's chart, this has happened to me before where I've come in the middle of the night and guess what? We don't have information to help us make a decision about the patients. Typically it's funeral stuff. So make sure that you're having those discussions. And I know what you're going to say, or you're saying to yourself, well, sometimes patients aren't ready. And that's true, but that doesn't mean you can't be having those conversations with the family members. And if they do make their wishes known to you, which a lot of people do, social workers, nurses, make sure you're putting that in the EMR so that when the triage nurse goes out at night, there it is. That's who they want. And here's a copy of their advanced directives. So the disadvantages that I've seen, this is just my personal preference here, is our living wills may not be specific enough. I've looked at wills where, living wills I'm talking about, not regular wills, living wills where the patient has not said exactly what they wanted in the event that something happened. And I've also seen them override by a treating physician, which shouldn't be allowed, but it is done lots of times in hospitals. And it does not immediately translate into what your physician's orders are. So maybe you haven't had a physician write orders specific to what is in the advanced directive. And so that would be maybe for tube feedings or special treatments or services. So when you admit someone and they have specific requirements in their living will about speech therapy, physical therapy, whatever it might be, make sure that that's transported into physician's orders. So for give you an example would be mine that says, if I have a stroke, I would be willing or be open to physical therapy and speech therapy if I could no longer speak for a specific amount of time. And then if there was no rehab potential, I guess is the word I put, then I wanted it stopped. But if my physician order doesn't specify that, I don't want you working with me, when my brain is dead for on and on and on, because physician's orders have said I want speech therapy and physical therapy. So that's just a little bit about how I interpret that. Some medical terms you should be aware of: end-of-life decision-making, it's called, life-sustaining treatment, artificial nutrition and hydration, and CPR, which is cardiopulmonary resuscitation. I had a phone call the other day from one of the hospices that I do business with and consult with about artificial nutrition and hydration. This is a very interesting case. This was a case where there was no advance directive, and the family wanted to pull the feeding tube on the patient. I think it was a son that wanted to pull the feeding tube on the patient. And in the state of Arizona, you have to go to court. You cannot automatically pull a feeding tube. So that varies from state to state, but this particular agency that I was consulting with is in the state of Arizona. And I ended up looking up the law. I think it would change in like 1990 or 1991. And I made sure that the hospice had a copy of that. So make sure that you're familiar with the laws, and definitely have your social worker look into that if you have any questions about it. Other terms are do not resuscitate, DNR, palliative care and hospice. There are actually two different types of programs. I mean, a hospice, yes, provides palliative care, but just so you know, a patient may be looking for or write in their living will that they're willing to go to a palliative care program. Remember, a palliative care program provides services for a patient that still want to pursue aggressive treatment, but does comfort measures. So if you need additional information on the definition of a palliative care program, feel free to call me or send me an email, because sometimes people have that in their living will. They don't want hospice yet, but they're willing to try a palliative care program. So you want to make sure that you're signing them on to service on the right type of program that they want. Some information to share with your patients and families on CPR. 12% success rate is done outside a hospital setting. 24 to 40% if done at a hospital. But if elderly and they have a terminal illness, only 20% of those people come to some sort of reaction to CPR. So in other words, only 20% of those people may recover, and that's even less in some situations, depending on the terminal illness. So you want to make sure that you are very informed about what could happen if CPR is done on someone with a terminal illness, and what the results could be, and allow the patient to make the decisions for themselves. This was the latest statistics out of the Emergency Medical Journal for 2020. So I'd always tell people, it's not like TV. It's not like you perform CPR and they come back the way they were before. Chances are 80% of people are not going to come back the way they were before. And once you've explained that to families, they tend to sometimes have a different perspective on that. So working with families, explaining to them about CPR, let them first of all know your policy. Have repeated conversations about it. They may not be ready to hear this yet, but let them know your limitations. For example, at our policy with Arizona Care Hospices, we do not require our nurses to have CPR. However, discuss what could happen in the event that their hearts are stopped. So in our case, we would explain to the families that we would have no choice, if you are a full code, but to call 911 to have you resuscitated. So there are some hospices that do require their staff to be CPR certified. So make sure, A, you know what your policy is where you work, and 2, that you update your policy based on whatever the governing body has decided that they want to be done. Also talk with your patients about what happens after CPR is not effective and they can be put on a ventilator. What happens with that as well. So it's important for you to have those conversations. I hear a lot in IDT, well, the family is just not ready to talk about that yet. Well, then you need to ease into that. They've already made the decision to come on to hospice. They know that hospice is end of life care. They know that it's a prognosis of 6 months or less, but yet they still are a full code. It's typically not the patient, it's the family that's just not ready to go there yet. So make sure you do that. So questions and concerns for your families would be, assess the family's emotional status. Where are they at emotionally? And what if the patient has no mental capacity? Do all your staff need to be CPR certified? And does my hospice have to follow a patient's advance directive? And the answer is yes, we all should follow whatever the patient's wishes are. But how many times have we been in a home where at the very last minute, the daughter or son have changed their minds and have not honored that? You know, that's a decision that they make that's beyond your control, but you should make sure you're educated them. And of course, the most important thing aside from this is in your documentation, every time you make a visit and have those discussions, you have it in your summary, you have it listed in your advanced directives that the patient has, that you've had conversations with them about it. So I've done consulting where I've gone in and the patient has had an advanced directive and you have had those discussions, but there's nothing in your documentation. And that may be for a number of reasons, but that has to be there. CPR, what will they not do? Follow your state law. So some questions that I've gotten from other hospices is, what if your hospice owns a freestanding inpatient unit and your unit has a restraint and seclusion-free policy, and you have this inpatient unit, must your staff be CPR certified? And the answer is yes. So the federal law says that if you are a hospice, you do not have to have your staff be CPR certified. You don't have to unless you have a freestanding inpatient unit. And if you do own and operate a freestanding inpatient unit that's considered a different entity, like a hospital, and then you must be able to offer CPR to your patients. You can refer to patient rights on this, 418.52, the federal Medicare hospice regulation. Does your hospice have limitations on what they can and can't do? So make sure that that is explained to your staff in orientation and also to your family, patients and families. Finally, one last bit of information on Advanced Directive, then we'll open it up for some questions, is physician billing. So there is, it became effective in 2016, 1/1/2016, that physicians could have discussions with their patients about advanced care planning, and they could actually bill for this. So it's code 99497 for the initial planning, and then it's 99498 for ongoing billing about care planning after that. So, and that includes hospices. So if you're a physician or your hospice medical director is having those conversations about initial care planning, they can bill for that, and they can also bill for ongoing stuff as well. So that's important. Some other resources for you for advanced care planning is NHPCO has a link to all the state laws. So if you're in another state and you're listening to this and you're not quite sure and you want to click into NHPCO and you're a member, go ahead and get that information. Also, caringinfo.org is also another place to do that. So that concludes the presentation for today. If you have any questions, feel free to submit them in the to Marco, and we'll go ahead and answer those for you. Marco, have we got anything in the chat box at all?
We have, Pat, and thank you for the presentation. So just a reminder, if you have any questions, you can submit a question through the chat feature of your Zoom your Zoom meeting sort of module there. So Pat, we did have at least one come in. I think we might have another one coming through. So let me just see here. The first question we have, Pat, is, can the hospice social worker do advanced directives once the patient does come under service?
Yes, of course. We initially like to have you come onto hospice services with advanced directives. That makes everyone's life a lot easier, of course. But if they don't have an advanced directive, which is probably about 80% of the time we get that, the social worker typically asks about that, or should be asking, when they go out and do their initial comprehensive assessment. And that gives the social worker an idea about what they have and what they don't have. She or he will communicate that to the IGD team and then work with the patient and family from there. But that doesn't mean that the rest of us on the team can't help with that and put them in touch with the social worker. So yes, absolutely, we can help them with putting that together.
Wonderful. Thank you, Pat. All right, looks like we have one more question that's come through. And again, if you have any questions, please don't hesitate to submit your question in the module there on Zoom. The next question, or I should say the final question, unless we have another one that happens to come through, is, what attorneys specialize in elder law?
There's lots of them. For Arizona, I would recommend Jackson White. They have multiple locations in Mesa, Phoenix, West Valley. They're all over. I have used them a good 30 years in my practice for sure. They do trust, living wills. They do everything. They're specialized in abuse laws as well, elder abuse. They are elder care attorneys. They also do guardianship. I've used them and gone to court with them. I've also used them for my own personal trust, and have recommended them to a lot of people. Another thing about them in the state of Arizona, wherever in the state, they will also go to the patient. So if your patient's, not feeling well, can't walk anymore, looking like they're going to be incapacitated soon, but they're so thin and frail they can't get to an attorney's office, they will go to an inpatient unit. They will go to the patient's home. They will even bring a witness with them, so they don't have to worry about, getting a neighbor or somebody to witness stuff. So that's who I highly recommend. That doesn't mean there aren't other elder care attorneys in the state of Arizona.
Right.
There are, and there's some very, very good ones all across the country. Should you need help with that, feel free to call me at 480-588-8200 at the office, and I'll be certainly happy to help you find an elder care attorney.
Wonderful. Thank you, Pat. Let me just double check here and see if we have any other questions. It looks like those are the only questions that have come through. Pat, thank you again for your time.
Sure.
Wonderful presentation.
Great. And hopefully we'll see you all next month. Please remember to register for any other webinars that you've missed that you want to listen to at www.azcarehospice.com. And hopefully we'll see you again on December 18th for prognostic indicators and documentation. Have a great day.